Good afternoon, everyone, and welcome to our webinar on the Renters' Rights Bill, a deep dive today. I'm joined by Jason Hobday and Bella Zavery over at Womble Bond Dickinson. Jason's focused on residential litigation and very much focused on the legal and regulatory perspective in this webinar. And Bella will be helping support us looking at more on the operational and institutional investment challenges. And she's also a special advisor at the ARL on this very issue. So without further ado, I think important we try and race through as much of this massive bill as possible. So I'm going to turn to Jason for the first question, and I think that's really just to focus on, what are the key dates, what's going on at the moment, and what are the timelines we're looking at?
Thanks, Theo. Right, you can hear me. I haven't got my mute on. Okay, so we had the second reading of the bill at the House of Lords, and that was on the 4th of February. Some of the Lords had voiced concerns about the reforms disproportionately impacting on smaller landlords and resulting in a possible exodus from the market altogether. So the Lords had proposed that some amendments were made to the bill, essentially seeking to water down the impact on the smaller landlords. It's unclear at this stage, as we haven't seen an updated version of the bill, but it's unclear whether many of those Lords amendments are going to be implemented or not. So I think it's a case of anybody that's interested in this particular area and the impact on their business, I think you need to keep a close eye on further developments and news that comes out in due course. So for the purposes of today's discussion, we're working with the current version of the bill, which is dated the 15th of January, as came from the House of Commons to the House of Lords. It's therefore, as I say, worth keeping an eye out for further commentary in the future. And the next stage of the bill will be the committee stage in the House of Lords. But at the moment, we're waiting on an announcement as to when that date will be. I think importantly, the government has already given an indication that they would like to see the bill with royal assent, and that should be expected by late spring or early summer. In so far as applicability, the reforms set out in the Renters' Rights Bill will affect all new and existing PRS tenancies in England only from the commencement of the Renters' Rights Act. It's important to emphasise that unlike the previous government's Renters' Reform Bill, which proposed essentially a phased implementation in respect of existing tenancy agreements, the Renters' Rights Act will not have that phased implementation. It will apply to existing PRS tenancies from the date the various sections within the Act are commenced. So that is a really important difference. So the key takeaway from that particular point is the sector doesn't have a lot of time to get its house in order, and so that's really something they need to be focusing on.
Yeah, I guess that the magic wand approach is the one the government's taking, and obviously important that members keep abreast of the Lords Amendment. There's so many coming through, but I think an important reality is to look at the bill as it currently is and really start to prepare, because I don't think it will change materially. And speaking of, I guess, the major changes, Jason, what are the kind of key changes and can you kind of summarize them in 1 minute?
I mean, the biggest, the headline grabber is the repeal of Section 21, which is going to consign the AST to the annals of history. The AST will be replaced by the assured tenancy. And the only exception to that is obviously, I think, is going to be where at the point the Act, that we get commencement of the Act, if there are existing possession proceedings in place, or if a Section 21 has been served but not actioned and is still within its shelf life period, that tenancy will not convert. But otherwise, if we're not in that category, then tenancies are going to become full assured tenancies. So with the repeal of Section 21, we're also going to lose the no-fault eviction, which is obviously a very strong tool in the landlord's armory. And landlords will then need to start looking, if they're looking to recover possession, they are going to need to rely upon a ground for possession to be able to do that. There are currently 17 grounds in the Schedule 2 of the Housing Act 88, but the government's looking to bolster this above 30. So they really are increasing the amount of grounds and also adapting them to make it easier for landlords to recover possession. There is going to be greater stability and security for tenants, and the flip side of that coin is there will be challenges for landlord and their agents in recovering possession. So it's going to be a shift from a 2-page notice to Section 21, which only requires the tenant's name, property address, and a 2-month notice period, to then there needing to be the landlord needing to actually make out grounds for possession, adduce evidence, persuade the court the ground is made out, and also with some grounds it may also be necessary to persuade the court it's reasonable to grant a possession order. So it is going to be a very different landscape, and at the moment a landlord really has an almost guaranteed way to recover possession. Under the new regime, that won't be there. If you can't make a ground out, you're not going to be able to recover possession. So there's a key difference there.
Yeah. And just to bring in Bella there, what sort of impact do you think that will have on, I guess, the operational side in the sector?
It's obviously substantial. I mean, this is huge. The operational elements are going to be hugely affected by this, because it means the ability to control what's happening on site, the residents that you actually have in place, dealing with tenant complaints if there's a problem tenant, all of that is going to become hugely more complicated. You've also got a challenge with skilling the people on site. As Jason mentioned, it was initially a 2-page document, very easily, relatively and straightforward for someone to fill in if they were applying for a Section 21 eviction. That's no longer the case. If you've got to fall under one of the grounds, it means somebody's got to start compiling that evidence from day one. That's not straightforward. You're going to have issues with tenants not wanting to come forward, even though they might have a problem. People on site need to be educated, and I think there's a challenge there, because we don't really have a professional qualification which deals with how operators and how operational staff are actually trained to manage this, which means there's going to have to be a very quick upskilling required of everybody on site.
That makes sense, and I think it's about being proactive in a lot of ways. I think there'll be a greater role to play for operators and staff on the ground, and it's being proactive about things even such as rent rises, which we'll come on to later, kind of getting that information out there and having, I guess, a bit more of a two-way street on that front.
I mean, I was going to say, I can imagine actually what's going to happen is a lot of operators will start almost compiling a record of everything that goes wrong with residents from day one. So every complaint, every issue, somebody's had a party, because that in itself then becomes evidence that you could produce in court if you needed to. Because the reality is, if you've got a neighbour that's causing an issue for a residential tenant, and they're potentially still going to have to live next to them until they're evicted, I mean, how likely is it that people are going to want to come forward and say there's a problem? Nobody wants neighbourhood disputes. So there is a challenge here that we're going to have to consider.
I think in the short term as well, just to add to Bella's point, I think in the short term as well, while operational staff are getting up to speed with this new landscape, I think there is going to need to be probably a greater use of external legal in the short term, while people get up to speed and get used to the new process and what's required in respect of evidence and what grounds can be relied upon and what the court process will involve. And at the moment, it generally is a paper-based exercise, unless you want money judgment. If you just want a possession order, it's a paper-based exercise. So therefore, it's a bit quicker and a bit cheaper. If you're not using the paper-based exercise, which will be the new landscape, you're going to need court hearing, and it will take longer because you'll need a court hearing. And so therefore, the time lag in being able to recover possession will be a factor, as will the additional cost that you'll need an advocate probably to attend the hearing and legal support in drafting the claims. So it is going to need to increase legal budgets, unfortunately, in the short term, I think.
Yeah, and I guess just in terms of what those tenancies look like, what do they look like from the tenant side, Jason, and how are they going to work?
Right. Okay. So yeah, at the moment, the majority of tenancies are fixed-term tenancies, and they will shift to periodic, and they will be a maximum of a 1-month periodic. And that, what I mean by periodic is it automatically renews itself indefinitely every month until it is brought to an end in one way, whether the tenant serves an NTQ, whether the parties agree a surrender, or the landlord recovers possession. It will keep renewing itself each month. So a factor to kind of bear in mind there is there will be no tenancy renewals required, and therefore agents, that's obviously part of their business model, is associated fees with tenancy renewals. So agents may need to look at restructuring their charging as well. So that's a key factor, is periodic tenancies.
And in terms of the impact, Bella, I think obviously that's a monumental shift. Do you think there'll be impacts on, I guess, the institutional side and on the management there?
Well, the costs have to be applied somewhere. So
Yeah.
actually, what we're likely to see is this is going to be inflationary on rents. We're going to see rents go up potentially, and I think that sort of goes against the principle of, creating affordability for residents and making sure things are accessible. What we're actually likely to see, at least in the short term and possibly, in the medium to long term, is that rents are going to become more expensive because some of these costs have to be absorbed, and it's going to become an inclusive rent, which is then, passed on to tenants. And that sort of goes against the principle of what the government is trying to achieve. So it's a bit of a challenge. And when we've already facing sort of inflationary pressures on rents, and rents are so unaffordable, particularly in hubs like London, it's not going to help matters. It's potentially going to make matters worse, which is not great.
Yeah, I have concerns as well about relatively new buildings and
Yeah.
as they're coming online, you often have teething issues in getting those lease ups right. It could become more challenging, and also in the metro hubs, like you say. I mean, I'm not planning to do it to any of our members, but I can see a scenario where, say I want to come to London for the summer. Why not just rent out a nice Grey Star or Quintain place in Wembley and give 2 months notice after you've had your little holiday let. So I think there
I
are
mean,
challenges about
that's
those
another
prime
thing as
places.
well. I'll say that's another thing as well that potentially gives rise to transient communities, and that's something that the government doesn't want, the local authorities don't want, people coming in for short-term stays and then disappearing.
Yeah.
It goes against the very core principle of placemaking, building communities, creating integrated and diverse communities. If people are only attending for short periods of time, then what you're actually losing is a fundamental principle of what is so good about our living sector, and that is the
Yeah,
sense of stewardship. People are there to build a home and a lifestyle.
definitely.
Um,
And Jason, jumping on to the next area, I guess a new term. I don't really know much about the written statement terms. Could you run us through that? Sorry, you're on mute, Jason.
Apologies. The written statement of terms, there's £1 in the pot already. Yeah, it must be given to prospective tenants before the tenancy starts. And at the moment, it's unclear as to whether it needs to be a separate document to the tenancy agreement, and the intention is to provide a summary of the key terms of the tenancy in let's say, a more digestible form, or could it be it's actually in whether it's intended to mandate that a written tenancy agreement is given, because at present a tenancy for a term of less than 3 years doesn't actually have to be in writing. It can be oral. So it's not entirely clear whether it's this separate kind of digestible form document that sits separate to the tenancy agreement, or whether it's actually just a written tenancy agreement. My instinct is it possibly a tenancy agreement should cover it, but I think again it's another one of these points that people need to keep an eye out for, and as to whether it is in addition to a written tenancy agreement. The statement must include details about the tenancy type, the property, the tenant, the landlord, and their various rights and obligations within it. So yeah, I can't be 100% certain at the present time as to whether it is or it isn't just a tenancy agreement that must be in writing, or a separate document. Insofar as the application to existing tenancy agreements, obviously that are in place when the Renters' Rights Act commences, landlords really need to be clear about this point. They have 1 month from the commencement date of the Renters' Rights Act to give tenants information in writing about the changes that are introduced by these reforms. And that will apply where a tenancy has been signed also before the commencement of the Renters' Rights Bill or Act, but has not actually commenced, has not started by the commencement date. So that's another thing to be thinking about. Is it's just a written version of what the reform set out and updates existing tenants.
Right. Okay. So it's almost like a public information type thing exercise.
Yeah, a little bit like that. Yeah.
It sounds like something hopefully institutional investors, Bella, will be ahead of, and something that we can churn out quite easily with the right support.
So I think you're right, especially when I say institutional investors, anybody who's large-scale residential landlord. You can do a lot of this with pro formas, and that's something that you can potentially produce fairly quickly. Few things to think about is, again, it's that training piece. Operators aren't used to doing this, so there's an element of training that's required there. There isn't really on the operational staffing side, there's not really a qualification which trains people how to do this. So there's a training piece. The other thing is there is obviously a huge amount of human cost in terms of how much time it's going to have to be spent to sort of go back to tenancies that are about to be put in place, and putting all these in place, especially if you're doing it on a volume. Potentially, I imagine some funders might also want to just see what's happening. And if you've got a funder on board, then you've got to go through the process of getting them comfortable with what you're proposing to say. So that's something that needs to be taken into account when you're doing your funding as part of your pro forma suite of documents. So there's a few things to do. It's a few steps. I don't think this is insurmountable, but I do think it's going to take human hours in terms of cost. It's going to take someone some time to pull all this together.
Yeah, that makes sense. And I guess the majority of the things that are staying the same. Onto the next slide, Jason. Is there a lot of changes around deposits, EPCs, etc.?
No change at all where deposits are concerned. Landlords have still got to protect the deposits, comply with the requirements of the authorised scheme, and serve the prescribed information, all within 30 days of receipt of the deposit. And failure is going to have some consequences for the landlord in the way that it currently does, with them not being able to serve a valid Section 21 notice. The landlord will not be able to recover possession unless there are exceptions. If it's on one of the antisocial behaviour grounds, which is grounds 7A and 14, the landlord would not be able to bring a possession claim if they haven't complied with the deposit requirements. And obviously tenants will also still be able to pursue the damages claim for return of the deposit, and up to 3 times the amount of the deposit. In respect of the other landlord compliance obligations, interestingly, the Renters' Rights Bill doesn't link in the way that the provision of those landlord compliance documents to a tenant before they take up occupation of the property is linked to the validity of a Section 21 notice. The government hasn't done that on this occasion directly. So it does it really by way of coming at it via the back door, because those documents will need to be linked to or updated on the PRS portal database. And if a landlord hasn't got an up-to-date record on the PRS portal in respect to the property, and therefore those documents are not there and are not valid or up to date, the landlord will not be able to recover possession because of a outdated PRS portal. So it in a way indirectly still links it to the ability to recover possession. The portal obviously is policed by the local authority, and so if docs are not provided, they will also face enforcement action. If the landlord doesn't register with the property with the PRS portal, the court isn't going to make a possession order.
So it sounds like quite a lot of admin work, but hopefully managing that portal will make it a bit more simple to keep it all in one place. And in terms of, I guess, when the magic one happens, when they do transition, like will it be a case of just trying to upload those things? You won't have to do a new EPC, but just uploading existing documents to the portal alongside the statement of terms and the new periodic?
Yes, I mean, we come on to kind of cover in a bit more detail the portal,
Yeah.
but yeah, absolutely, that will be the kind of central repository for all this key information, and the tenants, prospective tenants, and unfortunately, well, fortunately, we might say the local authority and any other relevant agencies will have access to that information to check it's all valid and up to date and compliant. So
I think something, Bella, that hopefully our members are more confident with potentially.
Yeah, I mean, I think that's right. I think I agree with everything that Jason says. I think the one thing that possibly is a factor is when you're dealing with large scale residential tenancies and you've got to register all of these on a portal, and you've also got to register them on letting agency portals, and there's home views and all sorts, especially for things like build to rent. There is a challenge there because there's a cost associated with all of that, and there's always a battle over whether it's a single cost per building when you're doing duplicate the same amount of documentation, or actually you're going to have a cost per unit, which unfortunately wasn't budgeted before. And I think that cost can build up, even if it's a small cost, it can build up a lot when you've got a large volume. So whilst it's not an issue per se, I think there is a cost implication here which possibly hasn't been taken into account for funds flow and that sort of thing. And that causes an issue for viability. It causes an issue for going to speak to your funders and things like that. So it's something to think about early. And I think you need support from the sector in terms of some of these providers and who are going to host some of these databases. There's going to need to be a discussion with them in an early stage, and I suspect that's a sector discussion rather than a individual investor or landlord discussion.
Yeah, understandable. On to something, I guess, a little more, bit more contentious and interesting is the right to request pets. I think ET is a good metaphor because we don't really know exactly what this looks like yet, what sort of pets you can have. We haven't had the guidance through, but Jason, can you talk us through some of the issues here?
Absolutely, yeah. So far as lots of tenancy agreements that are in place at the point in time that the Renters' Rights Act commences, if there is a prohibition within that tenancy agreement prohibiting pets, that's going to become redundant, and essentially implied into all tenancy agreements will be a right for a tenant to request a pet, and the landlord can't unreasonably refuse. We need a bit of meat on the bone as to what will be considered to be reasonable refusal, but certainly one example that is given is where, as an example, the landlord occupies the property under a head lease or a head tenancy, and there is a prohibition against in their head lease on keeping pets. Then obviously if the subtenant was to request permission to keep a pet, the landlord would need to ask their superior landlord, and if that was refused, then obviously that would be a good ground and it would be reasonable for them to refuse the request. The landlord can grant permission, also make it conditional on the tenant taking out insurance for damage caused by the pet, and that's not just damage to the actual demised property, but it could also be to communal areas and also the landlord's fixtures and fittings, and if the property was furnished. And if the tenant will not or can't take out that insurance, the landlord can make the condition that, okay, well, the landlord will go and extend their own insurance policy to include damage caused by pets, and the tenant will be required to pay any costs associated with that increase in the scope of the policy. It's going to have tight timescales for responses, and that's normally it's looking like it's going to be 28 days from the date of request for the landlord to respond. Those deadlines can be extended in certain limited circumstances. And if the landlord doesn't reply or unreasonably refuses consent, the tenant can apply to the court for an order requiring the landlord to comply with the implied right, or could make a complaint to the PRS Ombudsman via the landlord redress scheme.
Yeah.
And in order to avoid additional admin in requests from dealing with tenants seeking permission to have pets, the landlords really need to, and agents need to think about start getting documentation ready about kind of information to request from the tenant about the prospective pet, and also spelling out what conditions the landlord might think about imposing if it is going to grant it. And that might actually deter a few tenants from continuing further with it, but at least everybody knows where they stand if that document, that pro forma, is ready to go in advance of when the act comes in. So
yeah, and Bella, I guess our sector, BTR in particular, has been quite forward on pets and stuff, but what are the potential implications here?
I mean, so pets are always a close one to my heart, because obviously I've got a beautiful dog, and I'd like to be able to think that if anywhere I went to, dog would come with me because it's a member of the family, of course. I think our sector is ahead. Build to rent is ahead. I will say that comfortably, because it's one of the things which we're already thinking about. It's something that's already provided. There's a lot of, dog, cat facilities. And so I think our sector's in a good place to talk about and sort of already comply with this. Where are there challenges? Challenges, obvious one. We've got to have the insurance. So if you've got to, if you can grant consent conditional on providing a sufficient pet insurance, is there pet insurance products available on the insurance market? And I don't think there are. I don't think the sector's caught up yet. And I think that's a challenge, because how do you cost it? Now, where the sector's already ahead, build to rent sector's already ahead, I don't think it's an even playing field, because if you are PBSA, for instance, I don't think PBSA benefit in the same way that the build to rent sector would. So there is a challenge there. They might not benefit from having the right to demand a pet. And then the other issue is, if you're a smaller landlord, and I'm talking about the private PRS sector here, so these are people who've got 3, 4, 5, 10 homes, they're going to find it a challenge, because they've got a cost for this, and either they're going to absorb the cost, which they probably can't, or they've got to go out and get an insurance which doesn't quite exist. It suddenly becomes a very difficult situation for them. So we might see that influencing some people.
Yeah, that makes sense. I was just wondering which 3 reasons of the 3 reasons, Bella, have you got your dog? I like the ornamental purposes one. Is that just all cats? I think maybe.
Well, no, my dog's ornamental too. He's a Samoyed, so he's fluffy and he's white and he's beautiful and he's very handsome. So I think he satisfies all of those 3. I'm happy to put forward a case.
And on to I guess another contentious issue, and one that we're definitely still working on at the BPF as the bill goes through the Lords, is on those rental increases. Jason, some big changes here.
Yes, so to the extent that I think the various measures in the Renters' Rights Bill are going to influence private rent levels, I think strictly speaking, it is rent control by the back door, or possibly rent control light. You'll obviously, however, appreciate that open market rents are a key factor here, and that there are a plethora of other factors which influence market rent levels. But in respect of certainly in respect of rent bidding, which is something we're all familiar with, this is obviously being outlawed under the Renters' Rights Bill, and landlords and agents will not be able to accept offers of rent above the advertised rent. So properties will not be able to be advertised either without specifying the rent within the advert. And so that's possibly something that agents and landlords are going to need to make sure they've got the right procedures in place once an advert is going out, that it states the rent. And then obviously when the property is taken by a tenant and they're signed up, as part of the sign-up procedure, we need to make sure the specified rent in the advert is the specified starting rent in the tenancy agreement. Otherwise, we're going to potentially face enforcement action later down the line. Local authorities are going to be responsible for that enforcement, where landlords have either invited or accepted a higher rent than was advertised, and those fines could be up to £7,000, and the local authority will continue to impose such fines for repeated breaches. So tenants are also going to be able to raise complaints to the landlord redress scheme or the letting agents redress scheme if they find that that this rule has been breached. So we need to be making sure, certainly in respect of rent bidding alone, that is stopped.
That makes sense. And I imagine it across the kind of living sectors is primarily, I guess, the advertised rent on the website and the portal that you click through. But I guess there could be an issue around some of the prohibition on advanced rental payments as well. So
Yes. So that's also built into the legislation at the moment. Sorry, the bill. At the moment, what actually happens is, I think where people are applying for accommodation and the prospective tenant doesn't pass the affordability or credit checks, I think the workaround solution for that the sector has found is that they'll normally take a multi-period rental payment in advance, i.e. a quarter, half year, or a 4 years rent in advance. And under the reforms, that won't be possible anymore. So the maximum amount of rent that can be taken in advance will be 1 month. And that is going to apply from the date of commencement of the Renters' Rights Act. And obviously the consequences for this are prospective tenants are likely to be declined, or landlords are going to need to revisit their appetite for risk or their due diligence processes, or they might also need to start increasing the need for guarantors to be taken. So yeah, and in respect of existing tenancies that are in place at the point where the Renters' Rights Act comes into force, if, as an example, the tenant has a month before it comes in paid 12 months rent in advance, from the point that the 11 months rent that's left runs out of credit, and when the next multi-period payment under that existing tenancy agreement falls due, at that point in time, it will automatically convert to requiring monthly rental payments. So that's obviously another factor that is, I think, going to impact on how the sector operates. And also rent increases, I think, needs to be given some consideration to, because at the moment, rent increases can be dealt with in accordance with the terms of the tenancy agreement, whether there's a formula or not. And under the reforms, rent increases can only take place once a year. It will be by way of service of a Section 13 notice, giving a 2 month notice period. And the tenant will be able to challenge that if they are unhappy with the proposed rent increase. They'll also be able to challenge starting rents as well within the first 6 months of the tenancy if they consider the starting rent is higher than the open market rent. And ultimately, they will be able to make an application to the first tier tribunal to get a determination as to whether the rent is appropriate, and the FTT will be able to determine the rent at the lower level of whether it's the open market rent or the actual starting rent or the landlord's proposed rent in a rent increase. And so it's potentially going to, I think, put a spanner in the works, because I think a tactic might be deployed by some tenants, because I think the FTT, First Tier Tribunal, is likely to be overwhelmed with such applications for determinations of the starting rent or the proposed rent increase, and they are ultimately, such applications, the application fee is relatively low. It's a no-cost forum, so there's nothing to deter tenants from making such applications. And in fact, if an FTT does make a determination on a starting rent, as an example, when that determination is made, it's at it will be backdated to the application date when the application was issued. But that's only in respect of challenging a starting rent. If it's a proposed rent increase, the actual determination will come in either at the point of determination or at a date within 2 months thereafter. So I think if the FTT is finding itself overwhelmed with such applications, what I'm saying is tenants might actually start seeing this as a tactic to delay the implementation of a rent increase.
And so that's a major risk, right, Bella? I can see this as probably one of the more contentious issues.
Yeah, no, I mean, I think Jason's already said it. I think there's a couple of issues here. I could see this. So let's take them one at a time. So rent bidding is sort of prohibited. Could we actually see the reverse? Could we actually see landlords intentionally putting a higher rent and advertising a higher rent and accepting the one that comes closest to it? You know, we might see that, and that's a tactic that a landlord could very easily use. And what's that going to do is actually put pressure on rent. So it's that inflationary rent pressure. So we're talking about, you know, whether this is an underhanded way of looking for a rental cap, but actually it could have the reverse effect. It could actually mean that we're getting starting rents at a lot higher rate. And then people are saying, well, you know, tell us what you can get closest to that. And that's not ideal, but, you know, there is a risk that that could happen. And then coming on to where you're looking at revising the rent, actually picking up Jason's point, but actually I think there's no incentive. It's fully incentivizing tenants to do exactly that. You know, even if it's a reasonable rent increase, why wouldn't you put an application in, particularly when the cost is so low, particularly when the courts are overwhelmed? Why wouldn't you put in a challenge? Because actually it just defrays the amount of increased rent you need to pay for an additional period. So actually, I think what we're likely to see is pressures on rent. Rent's going to be higher. It can then be challenged, so there's a risk there. And even if a rent increase wants to happen, you're potentially going to find tenants are going to be arbitrarily almost increasing it. And I suspect we'll see forums springing up advising people to do exactly that. You know, you've got a rent increase, do this. It's not going to cost you a lot of money, and it means your rent increase is deferred for a period of time. That causes a challenge for landlords, because effectively it means they can't forecast their funds and their income review, and that's going to potentially also impact things like valuations, I suspect.
Yeah, understandable, and I think that's obviously still one of our key focuses as the bill goes through the Lords. We're going to have to rush ahead slightly in terms of timings on the improvement of living conditions. I don't, you know, there's some new standards coming in the DHS and Awaab's law, but I think broadly those in the sector should be, you know, fairly comfortable with those measures, and obviously we can catch up in detail on that after the webinar. But just in terms of the PRS sector database and the new membership of the redress scheme, what are the new kind of ideas around this, Jason, and what are the liabilities for landlords?
Okay, so in respect of the landlord redress scheme, this is going to be a compulsory scheme that's mandated. It's going to be operated by the PRS Ombudsman Service with an annual membership fee. It's expected there will be a fee per property, and landlords that use agents aren't going to be exempt, so they do need to be members of the scheme. The scheme is to provide current, former, or prospective tenants with a formal process to be able to make a complaint about a member of the scheme, and with the aim of providing a fair, impartial, and binding resolution, which supports quicker and cheaper resolution when there are disputes. And the hope is, obviously, we've talked about the impact on the tribunals and the courts from longer and more complicated possession claims or challenges to rent increases or starting rents. And the hope would be that actually, if this is a way of knocking some of those out and resolving some of those issues without it going to a more formal legal footing, this would obviously will help. Decisions from the redress scheme are going to be enforceable as though made by a court, and the decisions the scheme can issue or can kind of require landlords to undertake are issuing, as an example, a public apology or restorative actions, or even giving compensation to the tenant. Failure to register will have a sting in its tail. The property won't be able to be marketed for letting, thing one. The local authority will also have the ability to issue civil penalties of up to £7,000 for initial breaches of not registering with the scheme, and that could go up to 40,000 with a criminal prosecution if for continuing breaches. And in addition, tenants will be able to seek rent repayment orders against landlords if they commit an offence by persistently failing to join the scheme. So it does have some teeth, this. So it will be necessary to register.
Yeah, that makes sense. And I guess just quickly on the portal, from what I've heard from government is that this is very much a first step on the database, and it's going to be quite bare bones to begin with, but they do want to try and embed more things that will be hosted there, and try and increase its usefulness, essentially, because right now it's a little bit replicative, but yeah, it's very much a first step, and we'd certainly be supportive of better development. Just on, I guess, the impact of that, Bella, I think obviously it's just another thing to think about, but yeah.
Absolutely. I mean, there is obviously the cost of hosting this. We've touched on that before. One of the things I think is possibly going to become an issue is that once a property is let, you're going to be obliged to keep maintaining some of this data on a continual basis. With tenants being able to exit property so quickly, there is a chance there's going to be high tenant turnover, which means landlords are going to have to constantly keep an eye on this and keep those records maintained, because otherwise they run the risk of rental voids if a tenant decides to leave. So that there is that cost implication. It's the cost of whether it's going to be, as we said, one unit is one cost, or it's going to be a bulk one. Interesting to think about also is if you are selling stabilized stock, something that we look at, if there is under the redress scheme, there's ability for tenants to apply for, fines and things like that. Then actually, are we going to start seeing retentions being put aside to deal with what might happen on this when a stabilised stock is being sold? A building or a portfolio is being sold. Is this something now all of a sudden sellers will need to start thinking about as part of their exit strategy? Again, that's going to impact valuations. Where you've got, the obligation to make public apology, is that all of a sudden going to now start appearing on home views and become a factor that residents are going to become aware of when they're making their choices? So it's not only just like the apology element, it's the fact that it'll be public, it's the fact that it could be a deciding factor for tenants, and unfortunately it means that there is potential for abuse the other way, in the sense that tenants could potentially do this just because it becomes more cost effective for a landlord to apologise and resolve something quickly rather than it go forward. So there is an opportunity there, things to get quite complicated.
I would hope in that situation, the Ombudsman was going to take a fair and balanced view. So I
agree. I think it's more the time that it would take to resolve something like this, and the administrative cost, the legal cost, and it's also the reputational damage. It's the impact of the optics of being involved in a discussion like this. And there's always an imbalance, I think, when you've got a large-scale landlord on one side and you've got a residential tenant living in one flat on the other. The optics of something like that, it'll be very difficult to manage, I would have thought.
Yeah. And conscious of time, I think we'll get to some questions shortly. But I think, Bella, the first question for you, I think, what can people do to start preparing now, and what are the actions to take?
I mean, I think the difficulty is that we don't know what everything's going to look like until, you know, the bill becomes law. But there are certain things you can start thinking about is how to upskill and educate your operational staff as to what might be required. Having discussions early. You know, there are professional training they can obtain, but it will need to be upskilled very quickly to take into account whatever's required as a consequence of the bill when it becomes law. There is also discussions with your funders, you know, getting them on board, seeing what they're looking for, having conversations with them, and trying to deal with a lot of these things. And that means, you know, it's not that these things will be a problem. It's by engaging with, you know, with your funders and everybody at an early stage, because all of that takes administrative time. It takes time. And with the legislation coming in place, effectively, you'll be expected to move fairly quickly. So
Yeah.
it's thinking about these things, starting to having the conversations,
Yeah.
and working out where you need to be, you know, positioning yourself.
Yeah, exactly. So I think I'll wrap up there because, you know, we've bombarded a lot of information,
It
and
is.
you know, all of this in one go can seem a bit negative, but and you know, there are a lot of real implications. But at the end of the day, I do think that the sector can take heart from this change. I mean, it is once in generational change, and it does shift the rented sector, the PRS, onto a much firmer footing that makes it much more similar to home ownership, etc., much more stable, much more attractive to tenants. So I think it really kind of replicates some of the models we see in other countries, and you know, we can be really confident as the BTR, PBSA, and other living sectors that we can, you know, drive the quality and meet these standards, and really ensure that tenants get the best experience. So I do take some heart in it that it is a revolutionary change. It's scary at first, but you know, I'm a big proponent of our sector, and I think we can work through these changes and hopefully come out better at the end of it. I'm going to jump onto some questions now. I'll just have a quick chance to review. We've had a flood of them coming through. One area that we didn't get to was that sort of grey area in between licenses, etc. So this is about the question: will the qualifying criteria for an assured tenancy change? AKA, is it only a principal residence rents under 100,000 PA? So I think that's to do with like service departments and apart hotels. Is there a big shift in that area?
No, there's been nothing in the Renters' Rights Bill in respect of amending, I think it's Schedule 1 of the Housing Act 88, which sets out exemptions to the assured tenancy criteria. So you are, if you've got a tenancy over £100,000, or if, as an example, the three criteria for a tenancy to be an assured tenancy is you've got an individual, a dwelling, and they're occupying as their only principal home. Well, if as an example, we've got a right to rent scenario where we're letting our unit to a company to sublet, that will not be subject to these changes, because ultimately it will sit outside the scope and be an exempt tenancy.
Yeah, okay, that makes sense. And in terms of just a few quick fire questions, is the deposit period changing from 5 weeks to 4 weeks?
Not that I've seen, no.
Okay.
No, the only changes I've seen, it would be a change to the Tenant Fees Act 2019 that would need that to be implemented. And the only change I've seen in respect of the Tenant Fees Act in the Renters' Rights Bill is in respect of requiring a tenant to actually have a policy of insurance for when requesting a pet.
Yeah,
that would be a prohibited payment at the moment under the Tenant Fees Act, and so it's been tweaked to allow that to take place. So.
And similarly on I guess tenant fees and the rents, headline rents. So at the moment, most of our rents include heating and hot water. We do not charge for these separately, but presumably we could. Is that a change that could happen?
Yes, you could. There's nothing governing that in the Renters' Rights Bill. But there would be nothing to prevent a landlord splitting those costs out. Absolutely.
Yeah, I thought that would be the case. Yeah. Okay, I'm just having a quick look. I had a question from around advanced rent repayments and impact on the PBSA sector. I can try and answer this one. The latest that we have from the government, although it's not kind of confirmed anywhere, is writing, is that advanced rent repayments alongside similar parts of the bill would not impact the PBSA sector. But we are obviously continuing to try and clarify that and really nail that down. In terms of, again, fees on pets, Jason and Bella, is there an ability to, in the Tenant Fees Act, charge a pet fee, an extra pet fee, or is it purely insurance?
No, it's purely insurance at the moment. Well, is the suggestion about charging a higher rent if you've got?
I think it's like a bonus fee. Like if you got a pet, you have to pay extra, basically.
No, I
Like
think
a
that would,
licensing.
yeah, I think that would be a prohibited payment under the Tenant Fees Act, and I've not seen an amendment suggested in the Renters' Rights Bill to the Tenant Fees Act to allow that. It's only in respect of the obligation on putting an obligation on the tenant to take a policy of insurance, i.e. enter a contract with a third party, that is currently prohibited but will not be prohibited in respect of contracts of insurance for pets. So in answer to the question, I don't think you would be able to do that, to add an extra charge.
Okay, great. Yeah, I thought that would be the case. So yeah, just focusing on the insurance element. Just digging through a few more questions. There's a question here about rent in advance. If the rent in advance is not permitted under an AST, is there anything stopping a landlord and tenant agreeing a company let if the tenant is set up as a company to avoid the trappings of the Housing Act? Sounds like a tricky thing that people have been considering. I don't know, Bella, if you've got any view on that.
Well, I think the optics of trying to avoid anything that's legislation is always going to be a little bit of a challenge. I think in practice, when you've got a number of units being occupied by a landlord, for instance, potentially for their employees, it might be slightly different. But generally, I don't think there's a way of, I wouldn't say there's a way of getting around it. But Jason, tell me if you disagree.
If ultimately it's the company that is the named tenant, and it's a bona fide company registered at Companies House, and they enter the tenancy agreement, it would not satisfy Section 1 of the Housing Act 88, i.e. it would not be an individual. So therefore, I think it would be outside the scope of these provisions and would be what we call either a contractual or a common law tenancy agreement. So it would be outside the scope. And I think, therefore, the provisions in respect of advance rent payment wouldn't apply.
Yeah. Okay, that makes sense. That makes sense. And we had a quick question here, a bit of future gazing for you both. How do you think the student HMO market will be affected by these changes?
I mean, go
sorry,
on, you
you
first,
go.
Jason. No, you first, go on.
I think it's going to be quite problematic unless there are some. So obviously, there's a ground for possession that's been added in to make it easier for a landlord to recover possession. But I think insofar as locking the tenants in for a period of time, I think that's really going to affect the market.
Mm.
Because if they're not on a fixed term tenancy agreement and the tenant can theoretically move in on day one and serve a 2-month notice to quit, to vacate, is the landlord at that point in time going to be able to find another student to take that property? They might struggle. So I think it is going to have a negative impact on the student market, the HMO market, certainly.
I mean, I think there's a couple of things in there. I mean, first of all, we don't know what the decent housing standard is going to look like. So how different it's going to be from HMO licensing, we don't know that yet. The other thing is, you're right. Jason's right. There's going to be potential for rental voids. So actually, are we likely to see more mixed tenure developments coming forward? You know, is it worthwhile at an early stage for a large scale landlord to think about, well, actually, I need the ability to have some of this as residential and some of this as student accommodation from day one, so that I can flip things around if I need to. Are we going to see a bit more of that? Possibly. We don't know. Either way, this is going to put pressure on, especially smaller landlords. It's going to cause a challenge for them.
Yeah.
And again, we're going to see, I think, an exodus on that side.
An interesting question here, which I don't know the answer to, a little bit around the market for guarantors. So presumably people will be reluctant to be guarantors given no fixed term tenancies. I guess people don't want to be on the hook indefinitely. So how will landlords be happy for guarantor to be limited to 1 year or so? Like, I guess, how do those guarantee products work, and yeah, how would an indefinite guarantee work?
Ultimately, I think the purpose of the guarantor is to ensure compliance with the tenancy agreement and rental payments, etc., for the duration of that tenancy. And so I think in the context of an indefinite tenancy agreement, which automatically renews itself on a monthly basis, it is going to be a bit of a deterrent, I think, for somebody to step into the shoes as a guarantor to be on the hook indefinitely. And so I think there is going to need to be some thought about how we approach the guarantor arrangement, because certainly I would not want to be on the hook indefinitely for a tenancy agreement. And so we might need to start thinking outside the box about how we approach this, and actually certainly the proposed grounds for possession. If, as an example, a guarantor was only willing to sign up to a guarantor agreement for, let's say, 12 months on an indefinite tenancy agreement, that obviously, when that guarantor agreement runs its course, the landlord is going to want a new guarantor agreement entered into. And if that guarantor is not willing to do it, where does that leave the landlord? The landlord is the risk exposure increases at that point in time in respect of this particular letting. Can the landlord force the tenant to enter or to find a new guarantor? Probably not at that point, because they're already in a contract, an indefinite contract with them. And the only way the landlord can end that contract is either if the tenant voluntarily gives their own notice to quit, if they agree a surrender between them, or if there is a ground for possession. And if we can't make a ground for possession out, we can't recover possession of the property. So indirectly, however, if, as an example, we lose the guarantor, but then the tenant starts defaulting on rental payments, we are going to be very quickly into the territory of being able to have a ground for possession that we can make out and recover vacant possession of the property. So indirectly, we can get to where we need to be. But insofar as guarantor agreements, I think there is going to be a problem. I think a lot of guarantors are going to say, I'm not touching that, thank you very much.
I mean, the other thing to sort of add to that is, because you can't, advance payments are going to be an issue. You're going to potentially see people building up rental arrears, quite a lot of them, before you can actually take action in a court of law. So guarantors are going to be important in the sense that you effectively could have a substantial amount of arrears have been accrued at the point that somebody wants is able to take action. So guarantors are going to be critical, but is that going to lead to a situation where actually, if we are, as Jason said, finding people less willing to act as a guarantor, is that going to make properties harder to let, or actually are landlords going to have to start taking a view and accept that there's a risk in every single letting they enter into? And that's not really a very palatable position. Risk should not really be a factor. But if you've got no ability to evict tenants, you've got guarantors who aren't willing to stand up, that becomes a bigger problem. So actually, I think slightly reverse to what Jason's saying, I think guarantors are going to become even more important.
I agree. They will be more important. I just think from a guarantor's perspective, it's
agreed.
not an attractive
Nobody's
proposition.
Going to want it.
No,
Fully
absolutely.
agree.
Yeah, and just a couple of quick questions that I can handle, and then we'll probably have to wrap up, unfortunately. Thank you all for lots of really, really interesting questions. One on PBSA about the exemption. The explanatory notes say the bill exempts PBSA, but doesn't include that in the bill. And that will indeed be in secondary legislation. So that will come in secondary legislation as an amendment to the Housing Act 2005, I think. And another question around all the significant amendments within the House of Lords that could lead to a dilution of the bill. How likely is that those the proposed reforms will be diluted? I'll do a bit of crystal balling for this, but my expectation is pretty unlikely that the reforms will change significantly. That's because very much the messaging that we've been getting from government and all our work on this bill from the outset with Matthew Pennycook and the bill team has been very firm and not willing to give in on kind of any of the key measures, particularly of some of those things that some of the more kind of substantial laws amendments are changing. So I expect there to be not much movement. We are still making the case at the moment and working on several amendments, a few of which we're more confident about that are around selective licensing and are a bit more, I guess, less contentious. And then we've got some ones on rent rises and the Section 13 process, which we're hoping to push as well. But yeah, still a lot to work through there. But I think, like I said right at the start, it's really important for us to start getting to the grips with the reforms as is, because I think the majority of the changes proposed will go through. And with that, we've still got a load of questions, and thankfully both your emails, guys, are on there, and feel free to as well to reach out to myself with any of those questions. It's been a real pleasure to have you both. Thank you so much for a real deep dive on the Renters' Rights Bill. We will be working up some guidance for the sector, so do get in touch if you want to contribute towards that. And we're having another webinar just like this on building safety next month, so do get signed up to that as well. Thank you all so much for an excellent webinar.